end of the student visa hearing. The landscape of international education in Australia has just shifted beneath our feet. The right to a hearing for student visa refusals is now gone. It has been replaced by a mandatory on the papers review process. No more standing before a member. No more explaining your story in person. From now on, your future in Australia is decided by a PDF. So why did the government do this? Efficiency. Right now, the tribunal is drowning in over 110,000 cases. Student visa refuse have been taking nearly 2 years to reach a hearing. The government's solution is a bespoke process designed to flush that backlog. What does this mean for you? Speed. We expect wait times to drop from 18 months to potentially under 6 months. And for the genuine student caught up in the bureaucratic errors made by the department, this is a victory. But for everyone else, it's a high-stakes gamble where you only get one shot. As a solicitor, my biggest concern is the genuine student test. Subjective criteria, like your intent to study, are incredibly hard to prove in writing. In an oral hearing, a member can assess your credibility. They can ask questions to clear up a confusing bank statement or a gap in your CV. Under the new law, they don't have to. They can simply refuse you. And there is no clarification phase, there is no day in court, and the margin for error is therefore effectively zero. But don't think this ends at the tribunal. By cutting out the human element, the government is inadvertently opening the door to federal circuit court litigation. When a member makes the decision based solely on a document, they are more likely to miss a key claim. We're predicting an explosion of judicial review cases. If the ART won't listen to you, the federal court will have to. And the speed the government wants at the tribunal level will likely turn into a massive bottleneck at the federal circuit court level. So what is the position? Is this bill useful? It is useful for the system, but dangerous for the individual. If you're facing a student visa refusal or have already got one and you're in the tribunal already, you can no longer rely on fixing it at a hearing. Your written case must be bulletproof from day one. You need to treat your ART application like a final trial. In this new paper era, if it isn't on the page, it doesn't exist. I'm Nilesh Nandan, and this is the new reality of Australian student visa law.